Welcome, IP friends, to another episode of the annual Christmas IP series edition. My name is Rita Richinda, and I'm your podcast host. Now, if this is your first time listening to me talk about intellectual property rights, such as copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication, you are welcome to my podcast. You can please check the previous episode where I had a patent examiner from Kenya come talk to us about how patent applications are examined and intellectual property rights in the pharmaceutical industry. You can also follow me on all social media platforms. Just search for IP series on Instagram, Twitter, LinkedIn, Facebook. You can also subscribe to my podcast on Anchor, Spotify, Apple Podcasts, Google Podcasts, and all the other streaming platforms. For my returning listeners, you guys already know the drill. Thank you so much for always coming back to listen to me, and let's get into our conversation for today. So our next episode for the Christmas IP series edition is focusing on an area or a subject matter that is not widely talked about or acceptable, and that is in relation to whether interns or volunteers can be credited or acknowledged or even own an intellectual property that they created while volunteering or during their internship or while they were employed. So apparently this past week a lot of people shared their Spotify Wrapped showing how um the kind of songs they listen to, how many times, their best genres, best artists. It's more or less like a yearly routine. um I think I first experienced that in 2020 with my podcast, but this year it did for both podcast owners, the consumers as well, that is the listeners like you and I listen, most of my songs I listen to them on Spotify. Then there's the Apple one, but this story is focused on the Spotify Wrapped. And sometimes I just like to click on follow hashtags to find out what's actually trending and what's there to say. So basically, the Spotify Wrapped is like telling users their most listened to music for the year each year. And this year I got my own Spotify Wrapped, and I was super excited. But a post actually caught my attention, which made me do like a very short IP. I created like a short IP series content about it, and it was a story accusing. It wasn't an accusation, anyways, but this post, I'm trying to get it up. So this lady took to her Twitter, and she was like, "I invented the Spotify Wrapped." And I was like, what? Should I not? That question kept coming. So she was like, her handle is at whatever jewel. So she said, I really invented the Spotify Wrapped story concept as an intern project in 2019, and they haven't looked back since Moi. So Moi is laugh my ass out. Then she went ahead to post screenshots of like a documentation of her work and how she came about it. So she was like, I can't make this up. And I was like, yo. So it shows like a detailed. So it was actually called hashtag Wrapped In. So Wrapped, OG Wrapped, Spotify annual Wrapped campaign not only summarizes users' year in music, but prompt reflection. The original format creates a personalized data deck complete with a variety of your tops for the year and an accompanying playlist. What's missing? So I think the what's missing was like her suggestion. So she suggested that while the stats are pretty interesting and even come with a bit of screenshotable bites, Gen Zs require a bit more attention. We like to touch and feel, to scroll and post. With this in mind, I have retooled Wrap to allow for a more interactive approach. What's new? Stories, stickers, sites will no longer stop at a mere screenshot. Wrapped in is hashtagable, repostable, and an altogether shareable experience. I'm just reading from the document she shared on Twitter, and I was like, so I initially done like a very short post just highlighting whether interns can own an intellectual property. But digging more into it and having more people talk about it, I just thought it wise to do a podcast version of the short story I had done and posted on LinkedIn and also on Instagram. So we already know that an intern, most people delve into internship because they need that experience before going into the real world, not the main world. It kind of also helps build your profile, your career profile, shows that you are focused, and you're also driven to want to make a difference or learn from the experts in your industry. Now, she had posted that when it was first unveiled in 2019, she kept quiet about her involvement in actually creating the work. And it turns out that even when they had reached out to Spotify to get their feedback as to that, Spotify had responded saying that the Spotify rap concept was first introduced in 2013. Says hundreds of employees have contributed ideas and creative concepts that have made the experience what it is today. So I think what is going through my head now is, can she categorically state that she really created the world? Because now it's more like he said, she said. Spotify is saying they started this in 2013 and that several other employees have contributed, just like she had contributed to the creation of what the Spotify Wrapped currently is. So she's more or less like a contributor and can be considered to be a joint author to the work. But now, if you decide to look at it from the intellectual property aspect, starting from the copyright aspect, where joint authors, even for trademark and patent and industrial design or design patent as it's called in the US, a joint author or collaborator can be acknowledged as the author of a creative work. Now, as we know that intellectual property is more or less the creation of the mind, it protects intangible works or intangible assets that are creative in nature and innovative in nature, that involves you using your mind to put out a work out there. Now, it could be a book, story, picture, um, software, programs, design, color combination, the visual appearance of a work, etc., etc. Now, for copyright, what the Nigerian copyright provides is that for the purpose of Section 6, it says persons shall be deemed to be co-owners if they share joint interests in the whole or any part of the copyright, or if they have interest in various copyrights in a composite production, that is to say, a production consisting of two or more works, that is for copyright. Then section 12, sorry, that what I previously read was section 11 sub 6. Now section 12 says right to claim authorship. The author of a work in which copyright succeeds shall claim authorship of his work, in particular that his authorship be indicated in connection with any of the acts referred to in section 6, except where that work was included incidentally or accidentally when reported. So if you're reporting a current event or you're broadcasting, you cannot really claim authorship in that work. That is what it's saying. However, it goes further to state that you as the owner of a work can object to any distortion, mutilation, or modification, or any other derogatory action in relation to that work. That means this is you triggering your moral rights, whereby you can prevent a third party from actually trying to ruin or dishonor or cause some sort of give you like a bad reputation regarding your work by distorting it. So let's say, for instance, if Spotify had decided that, okay, this intern had made this contribution, we're going to use the Spotify rap for something else other than what it was proposed, something like that. And again, these rights are perpetual. You cannot transfer them, but whereby you do because you signed a bad agreement, or is your case. But let's look at what other IPs provide in terms of joint authorship or collaboration. Now, section 2, sub 4 of the Patent and Design Act provides that where an invention is made in the course of employment, this intern was actually employed um, at Spotify for 3 months, or in the execution of a contract for the performance of a specified work. So you don't have to look at her contracts, her roles and responsibility at Spotify. What was she actually asked to do? Now it goes further to say the right to a patent in the invention is vested in the employer. So whatever you create as it relates to your role at that company is in the hands belongs to that company. In this case, belongs to Spotify, or as the case may be, the person who commissioned the work, provided that where the inventor is an employee, then if his contract of employment does not require him to exercise any inventive activity, but he has, in making the invention, use data or means that his employment has put at his disposal, or the invention is of exceptional importance, he is entitled to fair remuneration, taking into his account his salary and the importance of the invention. And it's also, the entitlement in question is not modifiable, but by contract, and may be enforced by a civil proceeding. Now, basically, if you as an intern or a volunteer have a contract with the employer, and your employment does not require you to create any does not require that you to do any inventive activity, but you have done so by using data or anything belonging and that is within your employer's disposal, you are entitled to a fair payment, which, according to reports, the intern was paid. She got paid more than other people because of her contribution. And so it says she was paid and received a stipend during her internship, more generous than what many companies may offer, but it's no substitute for a real salary. Now, do you think at this point that, given what I have read, so we've looked at patent because based on how the Spotify rap was created, I think the most important IPs would be patents, which protects inventive work or solves problems in the society. What would apply here, whereas copyright will apply based on the fact that it was the picture, the documentation which she showed as proof can't pass as a work in a fixed medium, either as a book or a sketch, and every information that she put in there. So which is why I had made mention of copyright and patent as the IP that she can consider. And you can trademark the name Spotify Rap, but Spotify Rap already belongs to Spotify, because Spotify, just like Apple Inc., will want to protect everything that is linked to Spotify. For instance, Spotify podcasts. I know they have a Spotify room. I think that's what it's called. I had it on my phone at some point, but I deleted it. But yeah, that's about that. Let me now take you down to my Q&A sessions, where I'd asked if an intern can claim authorship. Can an intern claim ownership of the intellectual property? Yes, if you are an independent contractor, where the parameters of created in the course of employment is not vague. For instance, in your intern employment letter, it was um it will state or define what created in the course of employment mean, so that when issues as to authorship and ownership comes up, this won't be having this back and forth of people saying, or an intern or a volunteer saying, oh, I created this while working with this person. So as an intern, while you may be excited to get that internship opportunity with a particular company you've been looking forward to working with, it's very important that you vet or you read your agreement properly. It wasn't suggested in your contract, please suggest it. It also shows your employer that you are, what's the right word now, business focused, I would say. Also, if your employment gives you the opportunity to create work, say stating that in the course of working with us you create the work, you get to own it, please go ahead to register it. Don't waive your intellectual property right, be it economic or moral rights, or um um being tricked or coerced into signing all your rights, be it a copyright, patent, whatever it is. Don't sign it before you put pen to paper or ink to sheet of anything. Please get a lawyer to read it for you. Even if you pay a stipend to the person will probably understand. But make sure that you are reading everything. So it's possible for you to claim ownership of a work if these three things are in place. Where they are not in place, I guess you'll be at the mercy of your employer. But it's very important that you can raise it up during your negotiation, that even if you're not recognized as the owner, you like to be credited as the person who created the work. So for instance, when I put up this post, I got a message from someone who follows me online, and he was like, oh, this kind of reminds me of the Please Call Me Back case. I found out about it while I was doing my research, and I was just smiling because one, I had analyzed that case on Twitter, then I went ahead to do a podcast version and then a newsletter version. Even I think I did the newsletter version when there was a new update from the court asking that Vodacom pays the owner of the Please Call Me Back short code all his royalties. There was a fee that was calculated by the court, and he goes ahead to send me a link, and I was like, okay, I know about this case and I already did my review about it. He was like, oh really, send me a link. So I ended up sending him the link to read about it. But yeah, let me not digress again. So my thoughts: ownership will apply to all categories of intellectual property rights, which includes copyright, which grants you automatic protection from the moment your work is created in a tangible format and is original. Trademark must be for distinctive marks such as name, logo, or symbol, designed for new visual appearance of a product. So for instance, when the intern was talking about so according to the lady, she stated that um she was someone who had Spotify and loved rap. So that means Spotify had already started the whole rap thing. But she came and she made a presentation at the end of her intern project where she updated the older version, um using data to be more interactive, and and more in tune with social media and how the Gen Z um liked their thing and they bought the idea. That was in 2019. So I don't think it's fair for her to come out today to say that she originally invented the Spotify rap when all she did was improve on the already existing information. This is where patent will come in, where you're improving, even if something's already existing, but you improve on that invention. That makes you an author. But you cannot categorically come and say, what's that post now? Let me look for it again. So you can't come and categorically tell people that you invented the Spotify rap, whereas you improved on an already existing information that was out there. Now, also the fact that an intern used the equipment of the employer, or in this case Spotify, is not enough evidence that the employer or the commissioner should own the IP created with the use of that of their equipment within the facility. I mean, it's kudos to them too that they should have credited and said, "Oh, based we have a new update thanks to XYZ who helped us improve the older version to be what it is now introducing." So Spotify is also claiming that they give young talent from all background an opportunity to create, contribute, and learn alongside their best team. And that conversation is coming up because people started to make it a race thing that, oh, because she's a black lady, and we know how racism is in the United States, because she's black, they're not crediting her. Maybe it might have some truth to it, maybe it might not, because we've seen the TikTok backlash where black TikTok content creators like the dancers refuse to create um any new dance routine on TikTok because the white TikTok content creators were getting credited and acknowledged as the creators of these dances. Some even had opportunity of being featured on TV live shows, and they were called the author. So I get where the argument is coming from, but the real argument is on whether an intern should actually be not just owned but also be acknowledged as a creator. Um, in my presentation, I also talked about what rights that an intellectual property owner has, which includes the exclusive legal rights and protection in a territory that the work was registered, and basically registered. I won't say created because other than copyright and trade secret, the rest require registration in order for you to enjoy protection. I don't know if to say if the Spotify rap had some confidential information related issue whereby this information were shared with the interns to come up with their project ideas, and she used that information to develop what she already has. So there are issues as to public disclosure, access to confidential information, if she was even acknowledged, if she was actually an unauthorized personnel to access those information, would she still claim um, ownership of that work? Then an IP owner can commercialize and exploit their work by selling or licensing it, like we saw in the Please Call Me Back case. The employee had actually licensed his short code to Vodacom. So could the intern working with Spotify, who worked with Spotify in 2019, that is at whatever drill, could she have opted to license it to Spotify after leaving Spotify, or if she had done that, would Spotify accuse her of IP infringement at the end of the day? So while you're creating your work, you need to be very strategic about how you go creating your content. Then you can explore a multi-layered IP protection. So like I said, that we have copyright, trademark, patent, design rights. We have trade secret as well. This is not plant variety related or GI related, so I'll just focus on these types of IP, the 5 types of IP that I mentioned. So your codes, the object codes, subject codes can be copyrighted. It can also be patented. The software can be patented. Your documentation can be copyrighted. The name of your project can be trademarked. The visual appearance of your work can be protected as design. Information that if you go getting into the wrong hands would cause harm to your inventions or creative work can be protected as a trade secret. So those are things you need to consider. And I think companies should also have IP policy where they educate their employees, interns, volunteers on just have like an IP guideline basically. And you also have the right to enforce your exclusive rights as an IP owner, right to sue alleged infringes. I already talked about rights of a copyright owner, which is the right to reproduce. So only the original, no, let me not say original, only the author, sorry, only the owner of a copyrighted work can can reproduce a work, can publish it to the public, can distribute it to the public, can adapt, translate, or communicate it to the public. Just check what your IP laws in your country provides for you. I think another question that popped up in the course of this debate was, for instance, whatever drill was paid during her internship. I recall I read that where Spotify said that they gave her a generous amount. Now, would that pass? Would that still give at whatever drill the right to claim ownership of the work? My answer to that is, was the payment for her intellectual property in the work in the Spotify Wrapped, or was it an agreed stipend or salary from when she got employed? So those are things you need to consider. If all of those things were expressly said, so we're giving you, say, $1,500 as your stipend and an extra $10,000 for contributing to the Spotify Wrapped. Was that a one-off buy-off? Was it a contract to that effect? Nobody knows. But only whatever Drill and Spotify know the conversation they had, and why she never questioned all of this and waited until they eventually launched to come and start saying, oh, that is my invention. That's my invention. Story, this Spotify Wrapped story concept was an intern project I did, and Spotify bought it and never. So those are conversations. Did Spotify also make an offer to give her some sort of royalties that she can earn in perpetuity, that even her heirs can benefit or successors in title can benefit from it? No one knows. So what can brand actually learn from this Spotify Wrapped case between at whatever drill? And her usual handle is at whatever drill. That's why I keep saying at whatever drill before you guys think I'm being nonchalant, but no. First of all, my advice would be, have an IP policy within your company that encourages intern to contribute to the development of your company. And when that is done, they also get to be acknowledged. So other than being generous with whatever stipend you decide to pay them, let it be known to everyone that, oh, it's because of this intern that we got this breakthrough in this work. It's like the I can't remember the movie. I know it was Taraji that acted it with Janelle Monet, yeah. About the breakthrough with the launching of the rocket and all of those things. Also up to license the IP from the intern. That way everyone goes home happy. I feel that's like the best thing to do. Still brings me back to the please call me back short code case, where the employee had decided that, okay, I'm going to, so he informed his employer, so I created this short code that I feel will make a difference, and I would like to license it to you. And they went as far as putting out a memo out there, informing the workers that, okay, going forward, this employee created this and we are licensing it from him. I'm trying to get the name. Just hold on, guys. So I published that last year. I'm trying to go through my newsletter collection to get the name of the employee. But his story was really inspiring. I'm a sucker for love, so it was really an moment for me when I came across the case. So it turns out this employee had a girlfriend at that time who he eventually married. So his wife was his girlfriend at that time, and they used to have this issue where, you know, one party runs out of credit and you want the other person to call you back, but there's no way. So he found a way to create that please call me back short code that eventually blew. So his name is Kenneth Makate Nkasana. Yeah, there's a South African case between Vodacom, which started like, so he was a trainee accountant at Vodacom. was in a long distance relationship with his girlfriend, now his wife, and they had difficulty communicating. So that was how the please call me back short code was bettered, you know. He even went as far as negotiating and agreed with Vodacom that they will use his idea to develop a new product which will put on trial for commercial viability. The product was successful. He will get paid. So something like that arrangement should have been made with a whatever draw. I think Spotify should have. I mean, for a brand that big in the creative space, they should have opted for that. They should have opted for that. But that's just to give you an insight as to how sometimes when I'm doing my shorts, summarizing my thoughts as how I envision it when I get asked those questions. Then create a research and development facility or department to support interns or volunteers, IP or trainees, IP or whatever content or creative work or intellectual property they get to produce or make during their short stay in your company. That way you can use it to generate revenue, not just for the intern, but also for that department or facility that is in charge of, you know, improving on already existing technology or works that the company um, owns at that point in time. Then clearly define what created in the course of employment means. I mean, this one is very, very important. I think because I've had that discussion with people when they're like, okay, what if it was after work hours and I started to stay back and do some work in the company? Would that still be considered to be done on the course of work? And I'm like, it's dicey. If your contract expressly I think maybe because I'm a lawyer, I'm always focusing on what your contract says, but it's very important that when you before you sign any contract, read what it expressly says. And if it's not clearly defined, please make sure that they define it. Make sure they define it for you. So that you know that whatever you're creating, you can differentiate who owns what at what point in time. So let's say it was part of your responsibility or roles in the company where it was stated that, oh, you would be part of the project working to update Spotify Wrapped. It's clearly stated in your roles and responsibility. Now, argument as to ownership or you inventing something is not going to pop up because it's tied to a specific performance, a specific role, a specific responsibility as an employee or an intern or a trainee. Finally, but not the least, protect your confidential. Companies should protect their confidential information, include non-compete clauses in their agreements, non-disclosure clauses in their agreement with their trainees, interns, volunteers. That way, you're able to trace where the leak came out from in the event that someone decides to be, well, let's say, faster than their shadow. But yeah, in the event that someone tries to be smarter or play a fast one on you, you're already like 2 steps ahead of them. And to wrap up this conversation about the Spotify Wrapped case against at whatever Drew, I'm going to agree with what frankly Grace had posted on LinkedIn, where he stated that this argument is not about owning intellectual property right, but credit, giving credit to the contributor, recognizing and respecting the contributions to our culture and companies by those that rightly deserves recognition, respect, and credit, especially when those contributing are from people who have been historically overlooked or underrepresented groups. So, because it's a US case, there are very peculiar issues where um, the race card has been thrown in. There's even one that I'm about to um, review. It's about the Nike and the Omi and Key um, company who were accused of trademark infringement, unfair competition of Air Jordan 1 and Dunk. So that has a whole lot because the owners of the shoe that in question that is accused of being An infringing one is stating that so it was like, oh, this is how Nike started, and now they're not letting a black guy do this. So yes, so that particular post reads, the fact that they're seeing a young black man who started out exactly how they did is kind of crazy to me. Ironic how they tell us to just do it. So there are instances where the race card is being thrown up in IP, and I just think that IP is not sentimental when it comes to infringement. That is my personal view. So I'm going to be talking about that maybe in the next episode, the next 3 or 2 episodes, but that's something that I want us to take notice of. So before I wrap up, I just want to let my listeners know what the difference between a joint authorship and co-ownership. First of all, ownership or joint authorship basically implies that the contributors enjoy the entire bundle of rights that are accrued to the intellectual property in question. They are protected by the law based on the fact that it's a co-creation. They also inherit the rights of the author. Companies cannot be joint authors. For instance, let's say Spotify and another company decide to collaborate to create a work. They cannot be joint authors. One person has to be the author and the one trying to commercialize or exploit it. And in the event where they decide that they want to commercialize, say they want to license or assign the rights to the IP works, they need the consent of all parties and not one individual person. One individual party cannot have a final say. Whereas for co-ownership, it's sort of like restricted to some rights. It doesn't affect the whole bundle of IP rights that an IP owner has. It's also can be achieved through assignment of an economic right. It can also be passed to the heirs or successors in titles. Companies can be co-owners, but not co-authors. There's a difference between authorship and ownership. An author is the first person who creates the work. The owner is the person that gets to commercialize the work at the end of the day, because that person did not really make so much contribution, but they get to own the work. In co-ownership of a work that was not jointly authored, when it's assigned, it can be done without the consent of the original author. For instance, in light of our case for today, at whatever jewel, consent is not really required when they want to assign Spotify rap to another company, unless it was stated in her contract that in the event that the company Spotify wants to monetize or license or assign the rights to a third party, her consent will be sought at the end of the day. So I will wrap up here and be ready to get your feedback. So IP friends, we've come to the end of episode 2 of the Christmas IP series edition. I hope you found this particular episode really insightful, even though I was your guest for today. Stay tuned for the next episode, and don't forget to like, share, and subscribe or favorite on any of the platforms you're currently listening to me right now. Have a good weekend, guys. Bye.